Welcome again, guys. This is Casey Santana with Chief Entertainment. I am the host today for the Cannabis Chamber of Commerce. We have a full house today with some expertise that we're going to go discuss about the legalization and the rescheduling from 1 to 3, give you guys some insight on how to navigate in our industry and just give you some education on how that's going to look for many of us, whether you're operators, whether you're cultivators, or maybe distributors. So I'm excited to share some of that with you guys today. We have 3 guests for today. We have a representative from Clark Hill, TLG Group, and myself as well from the Chamber here in Southern California. So we will open up the chat for any of those questions. Or if you guys hear somebody talk about something you guys want some more insight on, please make sure you guys put that in the chat, and we'll go ahead and make sure that we address those as we go. So welcome, everybody, and thank you for joining us.
Thank you so much, Casey. And I thought maybe it would be helpful for the audience that are meeting this group for the first time if we introduced ourselves. I will begin. So my name is Safira Galoob, and I am the founder and the CEO of what I think remains the only lobbying firm in Washington, D.C. that focuses exclusively on cannabis reform. So my team and I have been doing cannabis reform in Washington since 2017. And if it's been happening in DC, we've been working on it. I'm certain that audience members are feeling what I call, when are we going to get there fatigue, which we're going to talk about that. My goal today with our expert panelists, I'll be moderating, is for folks to have a clearer understanding of how the process of scheduling works and what we can expect it to accomplish and what we should not expect it to accomplish. So before we get into the business of our efforts, let me introduce my colleague, David Mangone, to give a brief background. And then Bob, I'll pass it over to you. David.
Hi, good afternoon, everyone. My name is David Mangone. I am the Director of Policy for the Liaison Group. I've spent the last about 8 years doing federal cannabis policy exclusively. Prior to my time at the Liaison Group, I served as the Counsel and Director of Government Affairs for the patient nonprofit group Americans for Safe Access, which was the largest patient group representing medical cannabis patients in the United States. Have done some stints on Capitol Hill, as well as in previous administrations. I'm so excited to talk about the perspective today. And Bob, over to you.
Thank you, guys. It's a pleasure to be here. It's a great topic, the Schedule 3, or the forthcoming likelihood of a Schedule 3 designation or redesignation for the cannabis plant. My name is Bob Hoban. I'm a member at Clark Hill. I'm the co-lead of its cannabis industry group. And I've been working in the space for about 16 years directly, and been involved in policy, commercial litigation, corporate work, by and through Clark Hill and my prior firm, the Hoban Law Group. Really an honor and a pleasure to be here. And thanks to the Cannabis Chamber of Commerce for giving us this forum to talk about something that is not only super, super interesting, but in part controversial. And Safira, happy to be doing this with you and your team members. So good to be here.
Great. Thanks, everyone. So before we get into kind of the implications of 1 to 3, I want to start with kind of a level setting and a context setting. So frequently when our team goes out, and Bob, I'm sure you are similarly situated, that people ask, when is cannabis going to be legalized at the federal level? When is it going to be off the schedule? And so what we explain to folks when they ask that question is we understand why they're asking that question. But in the world of the way Washington actually works, it's actually not the right question at this moment. And so what I want to do is talk about, and I'm going to let David start with kind of the very 30,000 foot view as it relates to the legalization of cannabis in Congress, which is where we had been pushing so hard before President Biden initiated this in the White House, versus with the administration. So David, why don't you just level set, and then we'll get into where we are in the process, the administrative process. Go ahead, David.
Sure. And so I have seen a number of references, particularly on social media, that a president could legalize marijuana with the stroke of a pen. That is not exactly true. So there's a lot of processes involved that we're currently sitting in, the head of HHS, the attorney general by way of the DEA, they're all involved in that process. I think one step further than that is the current process that is used for scheduling drugs of any kind has very limited parameters in terms of what can and can't be done within that framework. So when you're talking about a descheduling event, the examples that most people tend to look to as to why cannabis should be scheduled is they talk about tobacco and they talk about alcohol. Both of those substances were exempted from the original drafting of the Controlled Substances Act in the 70s. So, we can sit and talk about the appropriateness of placing alcohol and tobacco on Schedule 1 versus cannabis. They statutorily have been excluded. So by extension, the definitions that exist within the Controlled Substances Act deal with accepted medical use and potential for abuse. Drilling down even further on the potential for abuse side, when you look at this administratively, one of the biggest things that is considered for potential for abuse is whether there's recreational use of a drug. So when you look at the adult use marketplace around the United States, as well as the illicit market that still exists for cannabis, you are hard pressed to reconcile that widespread recreational use by saying, at least in the statutory framework, that there is no potential for abuse as far as the DEA and HHS is concerned. So administratively, because there's a list of parameters that both of these agencies are reviewing and looking at, it is very difficult for them to come to a conclusion when you have widespread recreational use, both through adult use marketplaces and through the illicit market, that descheduling is ultimately appropriate. On the other hand, with Congress has the power and the prerogative to deschedule cannabis if they want, with that stroke of a pen. So we've seen efforts on both sides of the aisle where descheduling has been the core of the legislation that has been introduced. So you have recent history that shows the MORE Act, the Marijuana Opportunity Reinvestment and Expungement Act, that was passed out of the House, that was premised on descheduling. You had a bill in the Senate that had a little bit stronger of a legal framework in terms of what the role and responsibilities of each agency was. The Cannabis Administration Opportunity Act, introduced by then Majority Leader Schumer. He's still the Majority Leader, but at the time he was the Majority Leader as well. You also have proposals on the Republican side from members like Dave Joyce out of Ohio and Nancy Mace out of South Carolina that are more conservative in their approach overall, but still have elements of descheduling as part of the bill. So when we talk about the descheduling versus rescheduling piece, I do firmly believe that Congress, yes, has the authority to go ahead and deschedule or reschedule. I am less convinced that the administration, through its processes that it's set up within the CSA, would be able to get there as easily. So with that, I will pause and let Bob jump in if he has any thoughts.
No, David, you summarized it really, really well. I mean, to your point, it's been a misconception that the president can change this with the stroke of a pen. The president did what was within his purview by directing this designation, this examination of the present status of cannabis or marijuana scheduling to HHS. HHS, I would note, in a seemingly very prompt maneuver for a federal government agency, within 1 year plus or minus of being delegated this task from the White House, HHS came back with its findings. I'm not a student of this process outside of the marijuana or cannabis context, so I can't tell you things, whether that's the norm, but I can tell you that it's unusual for the federal government to do anything seemingly within 1 year. So this seems to be on an expedited track. And to that point, if I were a betting man, I would bet just about anything that this process does move forward towards Schedule 3 reclassification, and the rulemaking process, while it will not likely be completed in 2024 based on my perspective, it will be underway from a scheduling perspective with the DEA's next move. And I don't want to get too far ahead of ourselves, because I believe that this is one of those things that is an important voting issue for voters. And we do have a presidential election this year. Let's not forget that. And while I tend to be apolitical in most things, I think we can all agree that the R's versus the D's in this presidential election is going to be a hotly contested election. Every vote matters. And for Biden and the White House in its current iteration, it desperately needs, I would argue, every single voter on the cannabis issue to move towards the Democrat side, because as you point out, David, with some of the Republican proposals, the Republicans are trying to, in a sort of roundabout way, own this issue as well. And we've had this divide politically between the social justice and the criminal justice reform issues that the Democrats have advanced and the more commercial issues that the Republicans have advanced. And that really frames this issue really, really well. So then my bet is on this process moving forward, because even though it is in the hands of the DEA, it's an executive branch agency, and the executive branch, while not directly controlled per se in the day-to-day functions by the White House, it does take the lead in the direction of the White House. And our sources tell us that the White House is driving this, perhaps the reason why HHS came back so quickly, quote unquote, with their recommendation. And the last thing I'll note before turning it back to Safira is that the descheduling issue, this is where the controversy lies. The industry seems set on this notion of descheduling. And in fact, just yesterday, we saw a letter written by our Colorado former governor, current Senator John Hickenlooper, along with Elizabeth Warren and 10 other recognized senators, sent to Attorney General Merrick Garland and the DEA, which urged it to consider a recommendation for descheduling. And this is an important quote, and I'm just going to read it without getting into the weeds. Rescheduling to Schedule 3 would mark a significant step forward. I think we can all agree on that. But the letter continues, it would not resolve the worst harms of the current system, and that the DEA should deschedule marijuana altogether. It goes into some detail about what those harms are. But the point being, there is political motivation towards descheduling, but absent an act of Congress, I don't see descheduling happening, because that appears to be a political effort, a politically motivated cause versus the current administrative or agency-based cause, which moves towards rescheduling because the science, frankly, supports it.
So I think both of your remarks gave a tremendous amount of substance to our audience. And I just want to break it out so that we can actually build on it and go a little bit deeper. So to start with, and actually we'll start where, Bob, you ended, which is these congressional letters. So frequently when a bill is introduced in Congress, someone say, well, is that going to pass? I would just like to remind folks that the Safe Banking Act, which has passed 8 times out of the House and was a piece of legislation that passed out of the Senate Banking Committee. It was actually the last time Senate Banking Committee passed anything out was 5 years ago, with the most bipartisan support, has been in play for 10 years. So even though we see these congressional letters and we see them signed on by multiple senators, primarily on the Democratic side, deschedule, that is not an indication that there is the requisite support to get out of both chambers. If you look at, for example, the support you have in co-sponsorship on the MORE Act or Schumer's bill, maybe one Republican in the House, 0 Republicans in the Senate have supported full legalization. And because of the rules in the Senate around supermajority, or some things you all probably have heard of called the filibuster rules, you need 60 votes in the Senate. Simple majority will not do. So to start our conversation, we're going to put Congress on the shelf. And despite the congressional letters led by very great champions to urge the DEA to explain the importance of descheduling, to support why descheduling is the way to go, those letters are politically motivated, but not plausibly, they're not plausible in that they will be accomplished. So putting Congress aside for a moment, let's go back to the administrative agencies. And so folks know here, I would like to establish some facts. The first is a little bit of a misleading title that we have of cannabis moving from a Schedule 1 to Schedule 3. No one in this industry should presume or conclude that we are a fait accompli of absolutely landing on a Schedule 3. Now, we have a tremendous amount of evidence and support as to why we think we're going to go there. But this is not an exercise where when the DEA comes forward, they're going to say, You called it industry, you called it Sapira, you called it David, you called it Bob. We're going to be a Schedule 3. And we're going to get into a little bit as to why this is not a fait accompli. So where we are in the process now is that the Health and Human Services has completed its 8-factor criteria and its analysis. Normally, upon the transmission of said analysis, there would be no publication of the details of that analysis. But because of a very subtle and kind of intricate requirement that the federal government release documents under the Freedom of Information Act, or a FOIA request, HHS was required, or HHS decided to release an unredacted iteration of its findings in total in the last couple of weeks. And that is crucial because while the DEA is currently in the process of considering the scheduling of cannabis, the world knows what HHS said, what it intended, and what it's recommending. So I'd like to turn to that 252-page document, and I'd like to ask our experts what was notable for each of you in reading the document. David, let's start with you, and then Bob, you can fill in the blanks based on either what David said and you can agree with or disagree with. We've got some great experts here. Disagreeing is just fine, but I'm curious to what impression you had in reading that document.
Well, number one, you have a government agency saying essentially that they have been wrong for the last 50 years. I think that can't be understated. When cannabis was placed in Schedule 1, there was several recommendations that was not the appropriate schedule. They were largely ignored by the Nixon administration, and we have dealt with the consequences of that since the signing of the CSA. So having a government agency that is cabinet level say there is medical value to cannabis, I think it confirms something that a lot of the people on this call have known this entire time. But having that, I think, marquee headline that we do now have a government source and government research and government agents and government employees saying that Schedule 3 is the right classification, that is a tremendous takeaway from this document. Something that was also very interesting to me was the reliance on state-based data that is throughout this report. So when you look at the previous reviews of cannabis that were undertaken by the DEA, most recently in 2016, but some of the other reviews that have taken place throughout sort of the DEA's petition-based history, they ignore what's happening on the state level. They basically say that it is a non-factor to them, it is a non-issue, and they are making their decision based on what is available on the federal level in terms of clinical trials, in terms of data from the National Institute of Drug Abuse and some other agencies. So this shift to recognize not only what the states are doing as a valuable data source, but actually point to states like Maryland and Minnesota as examples of how to collect data from medical cannabis users, how to set up programs, how to set up regulations. That is a significant shift that I think bodes well for the future of this industry, saying that, look, the government is acknowledging what's happening in the states. They're respecting what's happening in the states, and they know that the states have already put in a lot of groundwork into creating well-regulated programs that could serve as an ultimate model for one day in federal regulation. So I think those are the two most significant things that I took away from this. I will start with positives, and then we can shift into negatives, I think, after Bob gives his thoughts.
No, David, that's an excellent point. And, I really hadn't thought about it that way. And you do provide that context from that wider perspective. I wasn't necessarily aware that prior efforts to examine the classification of cannabis where the federal government ignored the state-based data. So that's an extremely interesting point. What I think is significant, what we know is significant here is for the first time in history, we've got the U.S. government, which, for better or for worse, just about all governments around the world particularly on this issue, they reflect back to the United States. The U.S.'s treatment of marijuana and its scheduling, not only by virtue of the fact that it flows from the UN Convention on Narcotic Drugs, and there are numerous common signatory countries on that, they tend to take the U.S.'s lead on its treatment of this plant in particular when we talk about cannabis. So we have, for the first time in U.S. history, U.S. federal government agencies admitting and acknowledging that there are clinically accepted uses and data that would actually suggest that this plant is not necessarily harmful to society. I'll get to that in a moment, but rather can be beneficial to society from a clinical and scientific perspective. It's beginning to recognize data, to your point, not only from the states, but some of the data. We know there are thousands and thousands of studies out there in numerous different applications of how the cannabis plant's been used for therapeutics and scientific basis, that all of a sudden these studies, which were completely ignored previously, are all of a sudden fair game in this analysis. The other thing I would note that's important here, and I'll go back to that first point in a moment, is the DEA, who is the next agency, if you will, to consider its position on this rescheduling effort or this classification or reclassification effort. It's bound by HHS's scientific findings. So that's an important point here. The DEA cannot, as a technical matter, come out and say, well, we disagree with these scientific findings. So all of these findings, including the reliance or recognition of this state-based data, is extremely important for that reason. And the DEA is technically bound by those. But all of a sudden, this is, if you ask me generally, what's the upshot of a potential Schedule 3? I'd say 280E. Well, I'm sure we'll get to that. I won't get into the weeds on that now. 280E reform, but also you'd have the U.S. federal government recognizing on a global scale that this plant is not the harmful plant that we've had it scheduled as for all these years. It doesn't have to come out and say, well, wait a second, we made a mistake or we were lying to you. It doesn't have to say those things, even though kind of know those things are true. It can use science and the advancement of scientific processes and scientific data and advancement of technology to say, we learned some things, we know some things now, and we can recognize those things. But here's some of the things that I think are important. Number one, it comments voluntarily that alcohol, that marijuana, cannabis is less addictive than alcohol. It didn't have to bring alcohol into the conversation. There was absolutely zero reason that it had to bring alcohol into this analysis whatsoever. But it shows you this sort of mitigation of harms analysis that we look at as a society. It tracks with many of the arguments that so many people in the industry have advanced scientifically and otherwise, that this is less harmful than alcohol. So it brought that into the conversation when it didn't need to. Very, very significant in my opinion, because that always tends to be the comparison, even though I think many of us are tired of the alcohol versus marijuana comparisons. That's an important thing to bring into the conversation. Another thing, when it talked about its analysis, remember, Schedule 1, it has a high potential for abuse. Well, it analyzes the potential for abuse. And it goes on to say, and this was an important thing, in my opinion, it says, even if there's abuse of marijuana or cannabis, the abuse doesn't seem to affect society all that much. That's my paraphrase of what it finds. But here's what it says to back that up. The withdrawal symptoms of marijuana are just not that significant. It just doesn't affect society that much. And then when you throw the alcohol comparison into that and the withdrawal symptoms or the addiction symptoms having to do with alcohol, those are really, really important comparisons to be made. So those are some of the important things I think that came out of that document that was released. There was a Texas law firm that pursued this through a FOIA request to get the redacted pages made available to the public. That only came out less than a couple of weeks ago, 250 some odd pages. So if you haven't had a chance to review those 254 pages, it's available online and there's summaries of it. But I think that those are the upshots. The U.S. government's acknowledging that there is a beneficial clinical use for this plant, number one. It's acknowledging that even if it's abused, it doesn't seem to be that much of a blight on society. And number three, it brings voluntarily alcohol into the conversation, which is what so many of the activist organizations have argued for decades, if not really, really stringently over the last several years, that the mitigation of harms analysis is something we really need to consider. So those are really, really impactful.
And I appreciate you bringing those one from your vantage point of having been in the space for so long. And, I would say, as I think about where cannabis reform is going to take us over the next 10 years, and knowing we've got to get more moderates and more conservatives on board, and those folks are concerned with public health and safety, that is going to be their measure of whether or not they're going to permit more permissive cannabis reform, or even move towards a legalization, an environment of full legalization. To have this HHS document, building on what Bob said, say, yes, there's a broad spread, even a more widely spread use than other constituents or other, we'll call it drug use. But the correlation from harm is so dissimilar to the other drugs that we're not as concerned. And so that's going to really help as we go farther down legalization. And the final thing I would add, and this is a little bit of a lessons learned for the cannabis, I think, advocacy, but also for other psychedelics and other, we'll call them non-traditional medicines and other plant-based medicines, is the importance of physicians and healthcare providers who are regulated by the state in recommending cannabis as a health avenue towards health and wellness. And in the past, because cannabis was not an approved drug and not approved substance, there was language under prior analyses that didn't care what physicians thought. And so in this analysis, there was several references to the number of physicians who are recommending cannabis as a part of their health and wellness recommendations to their patient population. And so what that tells us is that when we are looking to introduce, we'll call them alternative medicines, or for many of us, it's day-to-day medicines, but medicines that fall outside FDA pathways, that our relationship with our local healthcare provider is important, not just in normalizing, but to establish kind of where our society is moving as it relates to personalized medicine. And so I do recommend that even if your relationship with a plant is like you've never considered it medicine, or you've always considered medicine, I do think this is a worthwhile read. I'm going to transition now to some more practical implications, because one of the things that before there was kind of talk about the scheduling, there was most people agreed that the way that IRS Section 280E was drafted from a statutory perspective, that it would remove the application of 280E, because that involves trafficking in a Schedule 1 or Schedule 2 substance. And if we're Schedule 3, we're not Schedule 1 or Schedule 2, so 280E goes away. So putting that aside for a moment, and we're going to talk a little bit about kind of when that could go into effect. But I want to look at some other kind of issues that our industry faces. And I'm just going to back and forth between the two of you guys. And I'm going to let you can comment on each other, but I'm going to let each of you take a lead. Bob, let's start with bankruptcy. I know you and I have had conversations about this. What do you think about Schedule 3 and bankruptcy?
It's a great point. So a couple of things. What I was told unequivocally yesterday by a couple of trade organization executive directors that I was talking to in separate calls on this exact topic, because I've been asking around, what do you think about this? I'll tell you what I think here in a moment. But they said that the minute that rescheduling occurs, again, as you point out, it's not a done deal, but if it occurs, the minute it occurs, there are dozens of marijuana companies, and I'll use the word marijuana versus cannabis because that is the federal designation under the law, under the Controlled Substances Act, that they're going to file for bankruptcy immediately. Now, here's where the bankruptcy issue gets a little bit interesting. So when you talk about bankruptcy, let me read something here. So when you consider bankruptcy, a bankruptcy court is to consider whether or not the debtor in possession, in other words, the person that files bankruptcy, the company that files bankruptcy, the trustee who assumes oversight over a company that files for bankruptcy protection, is not allowed to administer assets that are illegal under the Controlled Substances Act. So the words are important there. Illegal under the Controlled Substances Act. So by designating the plant, marijuana, as a Schedule III substance, does that mean automatically that marijuana businesses are lawful, compliant, or legal Schedule III businesses? Not necessarily, because there are stringent standards in place that I'm not so sure most, if not all, of the marijuana companies in the United States could meet. But furthermore, it would require DEA registration and the like to be strictly compliant. So that comes down to whether a court or a trustee would deem this activity, quote unquote, illegal under the Controlled Substances Act. Now, I'm going to sort of complicate that issue even further. When you look at our traditional notion of controlled substances, what are we used to? We're used to when we go to the doctor and the doctor prescribes us a pain med. They issue a prescription, or an antibiotic. They issue a prescription, and that prescription is then taken to a pharmacist. And that the doctor issues the prescription, the pharmacist gives us the prescription that we're used to having. Now, Schedule III under Section 829 of the Controlled Substances Act, and it does apply to Schedule II substances, it defines a practitioner. A practitioner is someone who can order the dispensation of a controlled substance. The word practitioner, both in text and in practice, does not specifically mean a doctor or a prescription. So there's an argument to be made that even if, when marijuana is rescheduled, that even if a marijuana business that is lawfully registered or licensed in a particular state, even if it doesn't register with the DEA, and even if that compound is not issued a prescription by a physician, that those state licensees would qualify under the plain language of the definition of practitioner, and that recommendation would qualify as an order from a practitioner, and that those businesses would therefore be legal under Schedule II or III of the Controlled Substances Act. So it really comes down to how we define a legal, quote unquote, business as to whether, going back to your question, Safira, whether a company can file for bankruptcy. Because you have to be legal under the Controlled Substances Act. And if you look at the plain language of the Controlled Substances Act, it would suggest that a practitioner can issue an order. Practitioner is widely defined. Arguably, a marijuana business that's licensed in a state would qualify as a practitioner, and a recommendation or a dispensation directly to a patient would constitute an order under that same definition under Section 829. If that's the case, then they're legal under the CSA. But if that's not the case, then they would be deemed likely illegal under the CSA. And if it's illegal, no bankruptcy. If it's legal, bankruptcy. So that's ultimately the test. And who's the arbiter of whether something's legal or not? Well, in the first instance, it's the determination of the bankruptcy trustee, whether they determine that or not. But in the ultimate instance, it's that bankruptcy court judge or judicial official who would determine whether it's legal under the Controlled Substances Act or not. Now, I hope I have not thoroughly confused everyone watching this webinar.
You haven't, and I'm going to simplify it for people who are listening.
Please do. Please do.
If somebody tells you you can file bankruptcy and it will work, they need to show you their analysis. And if they show you their analysis, it should, if it's correct, match the logic or the logic log frame that Bob just shared. And what that concludes to say is people can file, but whether or not it will be successful is not yet known to us and will not be known until we go through the process. And it could be the case that we may have, and this is something I haven't really seen because I don't practice bankruptcy law, but we may see differing outcomes in different jurisdictions. Is that possible also, Bob?
Absolutely. I mean, that's why we have appellate courts. Multiple, every district, federal district court has a bankruptcy court associated with that federal district. Those are trial courts, that courts that field the bankruptcy petition, but they are not the ones that determine issues on appeal. And those issues tend to filter up to the circuits, the appellate courts, and that's why appellate courts exist, so that appellate courts can take differing opinions from trial courts or district courts or bankruptcy courts and ultimately assimilate or ultimately conclude in that circuit what the rule is. And if the circuits ultimately disagree, it sets the table for the U.S. Supreme Court to determine whether these things are legal or not. But to your point, Safira, it really comes down to the detail and the level of analysis. And let's not forget, bankruptcy protection comes in multiple forms, but the two most prevalent forms we're familiar with are Chapter 7, meaning we give up. The company just needs to liquidate all assets, or Chapter 11, where we commonly refer to that as reorganization, right? The company's got some debt issues. It wants to continue to operate, but it needs to sort some things out and get some pressure relieved on it that's associated with paying bills on time. So anyway, I do think that it comes down to the courts and the differing interpretations, and you can expect conservative jurists to rule one way and more liberal jurists, and you can determine those by who appointed those judges oftentimes.
Well, and I think this is a good transition for David, because we're going to also talk, so as a reminder, the question on the table had to do with not 280E. We just addressed bankruptcy. Now it's how it impacts other issues that face our industry. And so, Dave Mangone, would you dispose of or address how a Schedule 3 would handle intellectual property protections? And as you're doing that, maybe talk about some regulations that could happen in specific agencies that may or may not clarify for us some of these outstanding questions.
Yeah, absolutely. So, I think along with the bankruptcy discussion, what intellectual property is going to be looking at is whether or not there's a lawful use for a trademark. So right now, lawful use prohibits cannabis companies in particular from getting patents as well as trademarks for really any cannabis products through the United States Patent Office. There's some state level patent protections, including in California, that you can apply for, but you won't have that nationally recognized mark that's associated with some other national brands. So the question becomes then, once cannabis is moved to Schedule 3, will the USPTO designate that change as a lawful use? I think we can't quite answer that question yet. There's certainly Schedule 3 drugs that are currently scheduled as is, namely Tylenol with codeine, who have patent registration, who have trademark protection. But at the same time, there is not a widespread use of trademark and patent protection for various ketamine products, also Schedule 3. And so it really becomes on the IP side, a risk assessment of where the USPTO and where these companies fit in terms of their analysis of risk. So, I don't think we can answer the question quite yet in terms of what happens to trademarks and particularly what happens to patents. I think there is another issue that exists within the U.S. Patent Office of a reluctancy to patent any sort of genetic material related to plants. That has been a longstanding issue both in and outside of cannabis, where the USPTO has been reluctant, unless there is a very, very specific genome or very, very specific cultivation method, to issue patents to sort of naturally occurring substances. So I think that is something that's also going to be resolved. I will say right now, I think there is a strong case for copyright protection for cannabis brands, even as is a Schedule 1. And the example I like to use is you can get copyright protection for a work of fiction that talks about all sorts of vile crimes and dealing of drugs and the most terrible sort of narrative that you can come up with, but you can get copyright protection for that. But of course, that is not rarely where the value is in intellectual property protection. We're looking at trademarks for brands. We're looking at patents for either formulations or genetic material. And the copyright of the copy on your packaging or on your website is probably less significant in terms of receiving those protections from the US government. So as we're looking at regulations that need to be put in place, I think it's important to emphasize how minimal the move from Schedule 1 to Schedule 3 is as far as it relates to concerns of the industry at large. As Bob mentioned, the Schedule 1 to Schedule 3, it's an analysis based on largely two things, and that's potential for abuse and that's medical use. This move from Schedule 1 to 3 doesn't care that there's an industry that is very closely watching this move. The move from 1 to 3 does not care about creating business parity with our businesses with some of the other businesses that operate in the United States. That's not the role of the HHS. That's not the role of the DEA. what that role will be filled by is some of these other agencies that issue regulations. So your departments of commerce, your Department of Labor when it comes to OSHA standards, your drug and employee testing. So what I anticipate is that upon a Schedule 1 to Schedule 3 move, there'll be sort of this cascade of agencies realizing that they need to update their own guidance related to the move. And so the example I'll use is right now, when you try to register for a pesticide with the EPA and you're a cannabis company, the EPA will issue a denial letter saying that there's no lawful use for pesticides for cannabis because it's Schedule 1. Meanwhile, they have a list of approved pesticides for hemp products. And as we all know, it's the same plant. So if you write them and say that you're a hemp company and you're curious as to what pesticides registrations they offer, they'll send you a list of approved pesticides. So an example like that, with a move to 1 to 3, I think you're going to see agencies have to adapt their existing policies. And I don't think this will all be through formal rulemaking, like we're seeing with the scheduling process. It may be a guidance memo. It may just be a shift of internal direction in terms of how agents look at things. But we are going to see, I think, a fundamental shift in agencies that are outside of the process right now, so not HHS and not DEA, respond to this move and this change in law and adjust their own internal policies.
And I think to add on that, administrative agencies that make up the federal government that are going to be interfacing with our agencies, our industry, even irrespective of the powerful role that states have and state regulators have, they have a very broad swath of discretion in how they decide to establish rules and enforce those rules. As a reminder to everyone on the call, when the Cole Memorandum was in place, starting in 2013 until Jeff Sessions repealed it, it actually directed attorneys generals to exercise prosecutorial discretion to not prosecute state compliant cannabis stakeholders as long as they met certain standards. And that was a Department of Justice agency memo. And so I believe that as this reform movement is evolving and frankly revealing itself to us, we will have agencies, one, more informed, and two, more momentum towards understanding how their respective agency is interacting with the industry as it evolves and grows. So I'd like to now kind of move to a couple of just other small points, and I'm going to ask you guys to do more succinct answers, not that your prior answers haven't been incredibly important, because I absolutely want to get to the questions. I know we have 2 questions in queue, and those that asked, I will not forget them. But I just want to get through some other pretty controversial topics, but I just want to hit a couple of quick things. Bob, will you talk a little bit about just generally FDA, because you touched on this when you were talking about petitioners, and there's been some concerns that, oh my God, we go to Schedule 3 and everybody's going to need a prescription. And I've got some opinions on that, but I would love for you to give a quick bite of that. And then David, you're going to talk about banking and uplisting, just to preview you.
Sure. Yeah. I don't know what the word succinct means, Safira. So maybe we can work
Take less time to give your answer, Bob. I only have a certain amount of time on the clock.
No, really good question. The FDA, people are fearful of the FDA having oversight. The FDA tends to be a thorn in so many industries' sides. It tends to move extremely, extremely slowly. By way of example, numerous years ago, the FDA had said it was going to develop a pathway for CBD from industrial hemp, for example. And here we are, almost 10 years later, maybe 8 years later, and they're still talking about CBD, whereas the CBD industry kind of rose and then fell. My point being is that the FDA moves extraordinarily slow, and ultimately oversight over these topics, particularly when we've seen the clamor for regulating marijuana like alcohol. Alcohol is regulated at the federal level, in effect by the TTB, which defers in large part to the states. There's a model there already. So I would urge any lobbying group that's spending any time in Washington, D.C. to steer this away from the FDA and its slow-moving processes. The FDA doesn't want this either, by the way. That's a fact. We know that from the inside. The states have had to step up and fill the void by and large. So we want to move this away from the FDA to the TTB. The FDA will require and apply the law very strictly, of course, as it's bound to do under the Food, Drug, and Cosmetic Act and under the ranking of schedules, which, as I alluded to earlier, does require a prescription or an order from a practitioner to get these compounds. It requires a DEA registration. It requires a number of other things that just are not practical or frankly useful for the existing state-based cannabis industry. So even if the FDA comes in and asserts itself, it's a slow-moving body that develops rules on a 10-year, sometimes 15-year basis. Look at what they did with nicotine vapes. It took them 20 years to regulate something that desperately called for regulation because those early nicotine vapes were literally killing people, yet they still took their darn old time to get this done. And I think that we need to steer it away to the TTB accordingly, because the FDA will apply factors that just are not relevant to the marijuana industry. And at the end of the day, even if Schedule 3 happens tomorrow, we're still going to require some sort of federal carve out, much like those budget riders that we've seen that prohibit the Department of Justice going after state-based authorized medical cannabis producers. So at the end of the day, the FDA is not necessarily the agency that we want this in front of. So those fears are real.
Great. David, banking, uplisting. Do we still need the Safe Banking Act?
Yes, we do. And so, there are banks and financial institutions that will service the industry right now. They are, I think more risk willing than some of your bigger banks, your JP Morgans, your Chases. But you have financial institutions that service the industry right now. You pay high premiums. You don't get all the services that a typical business do, but a recognition from the federal government that this is not as dangerous as they once made it out to be, I am convinced is going to bring more players into this space. More players means reduced cost of capital. It means more options for your business. That being said, with a move to Schedule 1 to Schedule 3, it doesn't deal with anything in terms of updating the FinCEN guidance. It doesn't deal with anything in terms of, creating a safe harbor because, and this may not be popular on this call, but most cannabis businesses, even with a move from Schedule 1 to Schedule 3, will still be out of compliant with federal law. And, that still, to me, requires the need for a safe harbor because you are going to still have very risk adverse banks who want that protection, who want that cover when that move happens, knowing that on day one, a move from 1 to 3 isn't going to necessarily make a business compliant with their risk program. So Safe Banking Act is still going to be needed. As far as uplisting is concerned, I will answer that question with, there are Schedule 3 drugs that list on the US stock exchanges. There are reasons those drugs are where they are, whether it's because they're part of a larger portfolio of pharmaceuticals, whether if it's a single company that is unilaterally focused on a pharmaceutical approach. Again, it is a question of risk aversion. Right now, the NASDAQ and the NYSE will list Canadian companies. They'll list foreign companies that are engaged in the exact same business as companies in the United States. They have been reluctant to list cannabis while it's Schedule 1 as far as domestic companies is concerned, because they are worried about, whether it's this administration or whether it's a future administration, bringing the hammer down and saying that they are aiding and abetting drug trafficking. So if they have assurances from Congress or if they have assurances from the administration that they feel concrete about, you will see more interest in bringing publicly traded companies into a reality.
Let me just add one really succinct sentence here, and that is, I've been told from our banking clients that the minute Schedule 3 is done, that those banks will begin to lend. I'm not saying that as a technical matter that it makes them able to lend, but they said they will absolutely 100% lend once Schedule 3 takes effect.
They still have to collateralize the debt. So you're not going to be able to put the plant up on collateral or the license. So they're going to have to be assets that are collateralized. Let's move out of implications of Schedule 3 and get to some of these questions. So I'm going to I'm going to actually dispose of these in not necessarily in the order that they came in. And it has the very bottom one from Josephine about elimination of 280E. I would like to direct everyone's attention to a Congressional Research Service report that came out a couple of weeks ago. David, if you could put that in the chat for folks, I think it'd be helpful while I'm talking. So what happens with the Congressional Research Service, it is a research arm, a think tank arm within the federal government. And when things happen either in Congress or within an executive agency, it does analysis. So we in the industry and lawyers like the three of us on this call had done the analysis that 280E would go away upon moving a Schedule 1 to a Schedule 3 because the way that IRS Section 280E is worded. The great news is that the Congressional Research Service actually proposed its own analysis or published its own analysis that confirmed and concluded similarly. So there is no reason to believe that we will not lose or that 280E would not go away. I think the question becomes, when does it apply? And this depends on the when the interim final rule or when DEA publishes its rule and when the ultimate scheduling decision is completed. And we will talk a little bit about timing at the very end of the call. I also am going to dispose of the first two questions together, which is, does rescheduling encourage the pharmaceutical industry and its numerous cannabis patients? And thoughts on Schedule 3 as opposed to declassifying entirely isn't a slippery slope. So I completely understand why the two of you asked this question. With all due love and respect, it's not the right question. And the reason is, please bear with me as I explain this to you, is that the process we are in now is one of many ways that we're going to see reform happen. So when the administration initiated all of this, beginning with HHS was limited to the analysis based on criteria established by statute. So if this industry, if you ask everybody in this industry, would they rather to have status quo for 10 more years or improve on the way cannabis is considered? If you don't answer improve on the way cannabis is considered, you're not really a part of this industry in the sense that it is what we are desperate for in order to advance. It is the next iteration of what we have to have in order to stay alive and to ultimately thrive as an industry. So even though it is not a perfect, we're not going to accuse the perfect of being the enemy of the good here, and we're going to be thrilled with an administration that finds for Schedule 3. The other question had to do with pharma, alcohol, and tobacco, and Bob and I have had multiple conversations about this. The states will stay in charge of licensing and the commercialization of cannabis. So cannabis industry stakeholders that hold on to their license and can stay viable will hold on to their license and stay viable. If pharma, tobacco, and alcohol get into space, it'll be because the cannabis industry sells it to them. And I want to be clear that I'm not saying that we shouldn't, but it's not like the day that Schedule 3 happens is that they come banging on our door with their, they may come banging on their door, but it's up to this industry to decide whether or not it relinquishes its position based on the economics of opportunity, not because of a regulatory change. So making sure that I address those questions. David, I'm going to have you talk about single convention and just do a quick Pat Prue update, and then we'll do some closing on where we are. Because I know, David, you can handle this in 1 minute.
Yeah, so the single convention has always been raised as a concern to prevent a scheduling move from happening. The DEA itself raised the single convention in the 2016 denial petition. In short, two significant things have happened. The first is that internationally, cannabis has been reclassified from the most restrictive schedule, saying that there is medical use. Within the treaties for cannabis in particular, the treaties allow countries to set up frameworks for medical cannabis. We have commentary before the UN from part of the U.S. delegation from a woman who's at the Department of State saying that the treaties provide flexibility, that they are encouraging member states to remain participants rather than completely dissolving themselves of the treaties. And then the other example that we can point to since the 2016 denial is we have at least one other G7 nation, soon to be maybe as many as 3, having changed their cannabis laws in a way that is inconsistent with the treaty. So that's Canada. We're looking at Germany as well. And then certainly if this Schedule 3 recommendation goes through, as Bob said earlier, the world is going to look to the U.S. position on this. So they are still a concern. They are still a factor, but it seems as though the people who are speaking on behalf of the United States before the UN and before the convention in Vienna believe that this will not be as restrictive as previously thought.
As we come to a close, thank you, David. I'm actually going to have the great Bob Hoban give his closing remarks because I am very disciplined about time. So, Bob, you only have 3 minutes. And in your 3 minutes, because you've been around the longest, you're not the oldest, I am, but you've been around the longest. I would like for you to comment because I want to give the fifth person who answered the question, I want you to talk about Schedule 3, the future of the industry, particularly as it relates to the illicit market, and then move into your closing remarks in 3 minutes.
Sure. Just want to echo, no risk that pharmaceutical companies want to own the functional equivalent of liquor stores in states. So stop worrying about that. There is already a pathway for pharmaceutical companies to develop cannabis-based medicines with the FDA already, regardless of scheduling. They just have to do it starting outside of the country. So let's get rid of that notion. Number 2, the alcohol industry already participates in a major way, but it's effectively selected to use the legalization of industrial hemp for its purposes to put cannabis-based beverages into the marketplace that are 100% federally legal. So I'm not worried about alcohol wanting to get into the closed-loop marijuana space anytime soon. Like alcohol, descheduling, alcohol was descheduled. That's where it went to the TTB. That was a political maneuver. That was by Congress. To David and Safira's point earlier, this is not something that we have to worry about, and that's realistic through agency action. So this clamor for descheduling needs to be tempered with reality. Political reality is that there's no political will right now with the 60 votes you mentioned before, Safira, in Congress to move that forward. So let's get past that notion and take what's given to us and learn how to work around it. The biggest upshot, to your point, is that it will free up dollars that are needed by the virtue of 280E. And by the way, for those of you that want to read it, it's 26 U.S. Code 280E. Just Google that. You'll see the plain language of it. It's only 2 or 3 sentences. Easy to see. That only applies to Schedule 1 or 2. The biggest upshot is that will increase the profitability of these businesses by anywhere from 20 to 40% if done correctly. Think about that. Cannabis companies will all of a sudden have cash which has been something that they desperately wanted to amass and acquire to service debt, to pay things, to expand. Cash will be freed up with 280E. And the biggest upshot is the U.S. government is saying that there are therapeutic uses and that this plant, despite what we've been told for decades, this plant is not as harmful as previously designated for whatever reasons they want to ascribe it to. But scientifically, that's a major step forward. This will affect the illicit market, because if it's a scheduled substance, the illicit market, it reduces the penalties, by the way, for people caught trafficking in controlled substances without appropriate registration. Schedule 1, the penalties are severe. Schedule 3, not so severe. So it has a criminal justice implication, which I don't know, Safira, might encourage more illicit or traditional market activity because the penalties are less outside of the licensed state-based system, but that remains to be seen. At the end of the day, please don't fear alcohol, tobacco, and pharmaceutical companies, because they already have their pathways to this, and they don't want to own state-based dispensaries, which is the system we're talking about. This has been an absolute pleasure, and gosh, I can't think of better people to do it with. So thank you, guys.
Thank you so much, Bob. And on behalf of David and myself from the Liaison Group and the National Cannabis Roundtable, we'll pass it back to KC, and a big thanks out to the Chamber for inviting us and including us in this important conversation.
Thank you, guys. That was very informative. And if you guys have any continuous questions, this will be up on our YouTube channel. So make sure you guys jump in the comments and we'll make sure we get that answered for you guys. Thank you guys for tuning in today. You guys have a great day.